what is the benefit and what's the upside and the downside to vibe coding, to using AI to write the code?
From a coder perspective, AI will enable you to write your code faster and quicker. And also, people with a lower level of coding skill can now be more productive. So AI amplifies your coding skill. From a technical perspective, the code that it generates might give you a proof of concept or a first initial product version, right? So that means you can test for traction very quickly. Now, the problem with it is that the code that it generates tends to be, unoptimized. And so that means that when you reach scale, you're going to have to spend effort at professionalizing the code and making the code more efficient. So that's the implications from a coder perspective. Now, from my perspective as a patent lawyer, I see that vibe coding enables anybody to clone any other software. Like in the example that you mentioned, DocuSign could be cloned in a day or two. So that means that you need to move your IP protection more toward upfront instead of waiting until the end, right? So you should be thinking about patenting at the time that you start coming up with your concept, because you're doing this so fast. You can document your ideas, and then work with a law firm like ours who can move very quickly to put all that into a provisional patent application, because your designs are still iterating, right? Once you get to a stable point, and then you're going to throw it out for testing to see if people love the product, see if you have some traction. The moment that you're probably going to iterate a few more rounds, and that's okay. In those iterations, you might want to do another provisional application. At some point, your design's going to stabilize, you're going to find traction, and you're ready for your version 1.0 release. That is when you should take that information, take the provisionals that you've done, compile them into a single non-provisional, which will get examined, and then file them. And so that's the best way that you protect your concepts, because now coding is no longer a barrier to your business model. It's now the idea. And that means you need to move much quicker, front load your IP consideration in the front end because of the speed that it's coming along.
If I'm using AI to generate my code, if I'm using vibe coding as it's called, what are my considerations? What's the upside and downside for me as the coder?
From a coding perspective, AI is going to greatly accelerate your efficiency. And that means that even, number one, the average coder will get far faster in terms of completion of the work. Number two, you no longer need to be an expert coder to create great software applications. Now, the ultimate end product of an AI-based code may not be as efficient as a custom crafted code. So the vibe coding methodology is perfect for, you can also tie this to the lean business methodology, where what you do is you code some sample first, then you release it out and you test it, and you get feedback from customers, and then you go back and then you do some more quick iterations. Ultimately, you're going to get into your target end software a lot faster than if you have to code everything by hand. Now, one downside of using LLMs to code for you is that the code may not be optimized. So that means that once you find traction, you are going to have to develop resources into it and clean up the code and make it run more efficient. But that is a good problem to have. If you look at Facebook as an example, they came up with this, the user interface, and then when it got traction and the servers were literally melting down because of use, that's when they hire PhDs to come in and fine-tune the code. So from a lean product development perspective, I think LLM, the AI vibe coding concept, aligns very well with that. You just have to be aware that the coding ultimately will need to be tweaked if it's going to be deployed as a professional, software.
Okay, now from the legal side, you use Claude, you use ChatGPT to generate lines of code for you. What's protected, if anything, when you're having your code created by generative AI?
Sure. If the AI just on its own creates some code, then that is not protectable under the copyright system or the patent system. Now, having said that, if you as a human guides the LLM and then you tell it what to do and it does it and it stitches it in, and then you in the end retain creative control over it, you are the author and that is patentable. So therefore you should document to the extent that you control the LLM, what part is done by you, what part is done by the LLM. That is excellent documentation to have in case somebody questions whether or not is this patentable or copyrightable because it was done by an LLM. Now, the Patent Office has come out and stated that just because you use an AI to help you doesn't mean that it is not patentable. But you just have to make sure that you retain control over it.
Let's take a situation where, because most coding is, it's considered more like fluid in that you're probably going back and forth between things. Like you're probably writing some code, you're probably using ChatGPT or you're using an LLM to help generate some lines of code for you. So, let's say your product is a combination of things you thought of yourself and some stuff you grabbed from prompts. Is your entire product protected? And also at what point, what aspects of your product are protected? And at what point do you claim or seek protection on them?
So the answer to that is it's answered by the way you claim the invention. So let's take an example. Let's say you created a new DocuSign type of system where you might have an interface to receive the signature, or you might have a voice interface where the person says, I signed this invoice. Let's use that hypothetical. And then that thing the AI translate that voice into your signature and stamp it on a document, let's say. So the component where it's novel is that I told the system that I want to have a voice input to simulate my, written signature. So that is the novel part of it, right? The AI just simply takes that and then map it into some handwriting simulating your signature. That component is done automatically, and so therefore that is not novel. So your claim shouldn't be trying to claim what the AI is generating the actual signature. It should be focusing on what you invented, which is you can use voice as a way to authenticate and sign a document. That is your invention. It is not the fact that the AI sign off on it for you, because if the AI did that, you didn't invent that aspect. So that's a made-up example. So that's a good hypothetical to use for reference.
Talk about the thing you wrote in here about why VCs are not prioritizing startups with patent protection. But tons of VCs are looking to invest in AI. So we're kind of in a Wild West era of AI. What trends are you observing with AI as it relates to legal considerations on the investment side?
Sure. We've seen that VCs recently, they relied less and less on patent protection because they think that it's too expensive and it takes too long. Well, Patent PC, we've changed that equation because we ourselves use AI to help us draft the application. So we've cut down the cost and the time. And our methodologies in interacting with the Patent Office also increases the allowance rates, and therefore reduces that time frame, the delay that the VCs are worried about. So from an abstract viewpoint, if coding is becoming so easy that anybody can copy you, why would an investor put money in you? We've seen examples of this in the Kickstarter space, where what happened is you literally on a Kickstarter, you have a video that describes how your product works. You have detailed documentation, the specification of how it should work. And we've seen many cases where you did that. Guess what? If you have traction on funding, your competitors out in, let's say, the Far East or down in Africa, they'll look at it and they'll say, "Oh yeah, let me clone that." And you'll see those clone product appearing on Amazon and eBay before even your funding, the closing of your Kickstarter project. So if I were an investor and now I'm saying, hey, AI has dropped the cost of coding down so that anybody can develop a software now, why should I invest money in a company that's going to be copied the next day? So therefore, it implies that patent and the IP moat will become very significant for startup founders in the future.
There are different kinds of patents that exist, right? There's utility, there's design, there's provisional, there's something else, I think. So I think it'd be good if you just talked through.
Yes, there are three types of patents. There is a utility patent, which covers how it works. And that is the most powerful type of patent because it covers the function, right? There is going to be a design patent, which covers how it looks. And a prime example of a design patent is the Coke bottle, where you see the ridges along the line. That's very unique. The bottle itself is not novel, right? But the ridges are novel. Now, another example of a design patent is this particular device. Guess what? Apple got a design patent on the square, a rectangular phone with rounded edges, and so that's a design patent. And that patent, Apple actually litigated against Samsung, and they earned billions from that simple thing. Then there's a third type, which is probably not applicable to us here. It's called a plant patent, and of course, the name plant is covering plants. So for maybe it might be applicable to you if you're in the ag tech space, but we mainly deal with software and mechanical and electrical technology. So for those, you really have two types. It's the utility patent application and the design patent. And within the utility patent, you got two types. You got the provisional, which is a temporary patent, and then you got a non-provisional, which is the one that is going to actually get examined. So that's the hierarchy.
Maybe it's sort of similar to that. Can you explain how you can have, the whole point of let's say a trademark, the whole point of a trademark is to protect, someone's name or someone's, whatever they're calling something, right? And yet you can have, let's say, a Pete's Pizza exist in two different places that have nothing to do with each other. But how is one not infringing on the other?
Have you ever wondered how two businesses with identically the same name in different regions can coexist in trademark? And in your particular scenario, those companies have not probably have not registered their marks federally. So if they didn't do that, you have, they call it common law trademark rights. You have trademark right as long as you're operating and selling products within a reasonable zone around your address. So let's say if I run a Pete's in Chicago and I have a Pete's in San Francisco, and they both are unregistered, they both would be able to coexist. Now, what happened when, let's say, the first Pete is in Chicago and they didn't bother to trademark it, and the second Pete in San Francisco did go through the registration process? What happened is now you got a federal right that they earned that overlays the entire United States. And that federal right is then carved out like a Swiss cheese hole in Chicago because the Chicago Pete's Pizza operated before they had applied for the trademark.
Okay, so let's talk about the the trademark that you filed on my behalf. So we had applied for a trademark over the name Startup Hype Man and one of my pitch formulas. The original response we got back was that it was under review, I believe because it was not specific enough or the name startup can be used in many different contexts. So can you just talk through, what they said in the initial review and then how you articulated the response to secure the trademark?
So recently we worked on a trademark for Startup Hype Man. We applied for that, and ultimately there was some pushback from the trademark office. And so here's the history and how we overcame that. So we first applied for the mark as a combination, Startup Hype Man. However, the patent office was concerned that they didn't want to give the exclusivity to startup alone. They required it to be together with the startup hyphen together. And so the solution to that was we submitted a disclaimer to the trademark office saying that, yep, we're not claiming exclusivity to startup. It should be startup hyphen as a combination. And that's ultimately how we got the term trademark for Rash.
Great. Let's spend a little bit of time talking about, I think if we can cover so I'll say that I think a lot of people, they see the cost of patenting or trademarking something and they're like, well, it's just some paperwork, so I'll figure it out and do it myself. Why don't you share I don't know if the word is the danger or the concerns with, if you're not a patent attorney, filling out any sort of trademark or patenting framework yourself, or paperwork, not framework.
For patenting, right?
Yeah.
I'll start with patents. So as a patent attorney, I've helped a lot of founders and individual inventors obtain patent applications. A percentage of this, I would say maybe 10 to 15%, have actually done their own provisional patent application, and they come to us. And so some of the issues that we see is that their applications are very thin on details. So if you have like a 1 or 2 page back of the envelope and you file that as your provisional patent application, and when we convert it into a non-provisional, it tends to be 30 to 50 pages in length because we have a lot of details that show, we expand from your concept to show how it works, right? And so one natural question they might say is, well, if you start off with a, back of the envelope invention disclosure or provisional, and all of a sudden you see in the non-provisional 20 or 30 pages of details, did you have possession of that? So I think the biggest problem that I've seen is lack of detail, number one. Number two, inventors do not understand the process, the journey of going through the patent office and what examiners look for. And so they would tend to think of themselves, oh yeah, I think this invention is very simple, and let me just explain this, maybe 3 or 4 blocks. The problem with that approach is that, number one, you're doing yourself a disservice by not building up the greatness of your invention. When you think it's so simple that I can do that in, a page or 2, you're underselling yourself, right? When you go to an investor, you want to say, hey, this business is fantastic. It has huge value, and it's really hard for anybody else to copy me. You don't want to go to an investor and say, it's so easy. I can do it in 2 pages, right? And then guess what? The examiner is going to review your application the same way. And so we as patent lawyers, we add value to that by putting your invention on a pedestal. We say, hey, look at this beautiful concept here. It is, amazing. It is so, even though it is simple, simplicity itself is in this year of non-obviousness. Steve Jobs, his products are simple and easy to use, but nobody would say that Steve Jobs' product is easy to clone, right? So we frame the invention in a way that it looks sophisticated and slick and novel. So that's the first thing, is the framing of the invention. If you as the inventor come in and said, oh yeah, this thing, I can describe it in a couple of pages, guess what? The examiner is going to think this thing is simple, obvious. Number one. Number two is, in the space of software, you run an extra hurdle of, they call it patentable subject matter, or it's called the ALICE test. You can Google this. You say ALICE software rejection. What the examiner is saying there is, your invention could be implemented by a human mind. And even though it might take a human mind 1,000 years to do what the computer did, it's doable in a computer, in a human mind. And because of that, it is an abstract matter that is not patentable. So that's basically what the ALICE is saying. Now, how do you walk around that? You walk around that by showing that your invention improves performance of in some way. So let's say it could be you can make your computer run a lot faster with your technology, or you can increase the output, the quality of the output. So let's say you invented something in the compression space. You need to show the examiner that, hey, my invention compressed the data down to 30% more efficient than the best prior art. That tells the examiner that you have done something that is more than just the concept of compressing data, right? So there are a lot of things that the examiner checks for at the patent office that because we deal with them all the time, we will document that in the application so that it will address the questions that the examiner has directly in the application. And that cuts down the argument. You can imagine the examiner is going to come in. Think of it this way. He's going to apply the usual test. Oh, software, okay. Alice 101, not patentable subject matter, number 1. Number 2, this thing is obvious. I'm going to look at the keywords of what you do, and I'm going to hunt down those keywords from 2 or 3 patents. That's their basic algorithm, okay? And so what you need to do is anticipate all of that. And for some inventor who is focused on coding and never seen the space to go in there and write a patent application and anticipate what's going on in the patent office, that's going to be very challenging. And think of it this way. Is your value better at coding the next, Google, or is it better to learn and read a book, spend a year reading the book on how to do a patent yourself and ignoring the value of what you really do as a coder? So in short, that's why lawyers are still surviving in this world, even with the AI technology and onslaught of, technological advances that, but that possibly could say, oh, they could replace lawyers. There's the third thing we haven't mentioned is the strategic aspects of claiming your invention. So the first thing we've talked about is getting past the patent office. The third thing we talked about is, okay, could you think about how to claim this in a way that covers more than your specific use case? And that has significant value in the patent. So let me give you an example. I architected the Invisalign patent portfolio, and it has numerous technologies in there. 3D printing, it had computer-aided design as applied to dental, the teeth, the modeling. It had, they call it intraoral scanning technology, which is the technology that scans and digitizes your teeth structure, right? All of those things were patented. But guess what? The most powerful patent in the whole group was a patent that we said, hey, you can't have more than 3 retainers that are with a sequence indication on it. Now, Rajiv, do you know why that is significant? Why is it that there's a patent that says you can't have more than 3 retainers with a sequence indication on it? What does it block?
No.
Okay.
Tell me.
So Invisalign works by creating molds of your teeth, and each sequence that you wear, it applies pressure slightly to move your teeth by, I think, 2 millimeters at a time. That's the maximum that you physically can move a teeth without harming yourself. Okay? So guess what? The entire invention of an Invisalign is you have invisible devices you would wear. And how are you going to treat somebody if you cannot have a sequence indication on those retainers? Without that sequence, all your fancy 3D scanning and CAD technology and 3D printing technology, all that is worthless. So you can see how a value of a lawyer perching above what you've done can add a huge value add. Have you ever heard of the Alice test as applied to software and AI and even biotechnology space? Well, there's a requirement called 35 USC Section 101 that defines patentable subject matter. And that rule excludes math, laws of nature, things that existed in nature, like let's say vitamin C, plants that already previously exist from before you. So in the 70s, the court says that anything under the sun is patentable. And that really encouraged a lot of software patent applications to be applied for. Now, I think the problem with that is that now we have too many software patent applications and it can block the field. So the judicial trend recently is to restrict the scope of software patenting. And in a famous case called Alice, the court there enunciated a two-part test. The first test is, is this a potentially classifiable as an abstract matter? So i.e., could this thing be done in the mind? Could it be so high level that it could be done, in the mind? So, and we'll get to an example of that. And so assuming that you fall into that threshold, which, software arguably is going to go into there, then there's the second prong that says, did you do something more than conventional to take it out of the abstract matter test? And so when they say that, they mean that did you do something that is different, that improves the efficiency of the machine or the resulting product that is in a way is a type of what is called obviousness test, right? So let's apply that to a tangible example. Let's say you came up with a watch or a wearable device that has the LED and it bounces lights into your skin, your veins, and the light reflects backward. And you detect that, and then you can then measure heart rate or blood pressure or glucose level. Well, I ran across into that in one case where we did that, and the examiner says, well, all you're doing is you're just sending light into the skin, measuring the reflection coming back. We even had language that was saying we have sensors to detect that the wearable device, moves relative to the skin. And when it moves, it compensates because of skin movement, right? So it's a motion compensation. And even with all that, the examiner came back and says, well, all you're doing is, shining light into the skin, and then you compensate for it, using motion, sensors. That's an abstract idea. And so when we pushed back, we said, well, how is that abstract? We have a physical device that shines light into the skin, and then another device that detects the reflection of light coming back, and then we're compensating for the motion. And then we use the output to then estimate, a particular blood pressure or a heart rate. That's very specific, right? And yet we run across that Alice 101 rejection. So we talked to the examiner, and he said, well, I noticed that you have some real-time determination in there. And real-time, you can say, you can probably throw in there and it might take it out of 101. So we did that. We did what he suggested. Guess what? The next thing comes back, he ignored his own suggestion. So sometimes with certain examiners, you can get into those traps. And so you just have to keep on negotiating with the guy and sensing it. So unfortunately, the Alice test has the analogy into Alice in Wonderland. There is no clear boundary. And in fact, right now, there is a discussion of Congress action to basically get rid of that test, because that was a judicially created test and it just creates so much uncertainty. Depending on the examiner you get, you may just go straight by without any problem. And then in some other examiner, they can stretch that definition so far out that even a mechanical device with sensors deflecting light into it, the examiner would say, this is an abstract matter of just shining light and detecting reflections. It could be done by a person. So that's an example of this controversy that's raging right now with patent attorneys, is because if you get into that trap, you got to fight hard to get out of it. But it is possible to get out.
As an investor, what should I be looking for if a startup claims that they've got a patent on their product?
If you are an investor and you're reviewing an investment into a company and they claim that they have filed patent applications, here are the things you should check for. First, you need to understand if they have provisional patent applications or non-provisionals. Provisionals are temporary patent applications that need to be converted into a non-provisional within 1 year. And startups can do this to save money, and that's a very worthy goal. However, the application should have a lot of details in it in order for the provisional application to have any value. So let me give you an example of a good, high-quality provisional. those are done typically by drug companies. And what they do is they provide tons of details in there. And they write the application as though it is a full non-provisional, but they file them as a non-provisional. Why do they do this? Because they can stack the life to extend the patent life to a total of 21 years. 1 year from the provisional, 20 years from the non-provisional, and you got 21 years. And for drug applications, the last year of life is worth billions. So that's the best way to do a provisional application. Now, you don't have to be that professional in order for the patent application to be good. What you have to do is look to make sure that there's tons of details in the provisional application, and make sure that the company has a docket that makes sure that it's filed before the 1 year period. Because here's the problem. If they miss the deadline and they sold their, let's say they went out and they did a proof of concept test to validate traction, let's say 6 months from the filing of the provisional, right? And they missed the 1 year deadline. Guess what? That means that they're going to have to refile the application, let's say a year after they filed the provisional, but they have a sale in between. Now, that sale or that open use of that software constitutes a public disclosure. And that public disclosure is prior art against any subsequent patent application. So, if that situation happens, your patent is gone. Now, the only thing you can recover from that is now to patent version 2 of the software. And it may be good, it may not be good. But in this day and age where anybody can code using AI, you need to have a strong patent to defend the exclusivity of the business. So that's the recommendation that I have is, number one, check the quality of the provisional application, not for legally, but just for the technical disclosure details. Number two, make sure that they have somebody who's going to file the patent application as a non-provisional within the 1 year period, and make sure that they aren't just, doing it themselves and they may forget about it. That's going to be a crucial loss of IP rights, not just in the US, but also in the rest of the world. So that's a takeaway for an investor.
Every 1 to 2 months, Slack pushes out a new feature or an update. Now, do they have to go through a new legal process before every feature release or update to the software? Or does your initial patent cover upgrades, or does it only cover it in its current form? And how do you navigate that process?
Be glad to. So what you're talking about is a very normal process for companies to release iterations of the product. So you always have version 1, version 2, version 3. You have Windows, 1 to now Windows 11, right? So you have iterations of this. The foundational patent, the base layer, the reason it's foundational is that because it is the earliest expression of your inventive technology. So that is something that you file. And from a strategic viewpoint, we always keep that alive. And we do that through what is called continuation application. So let's say you file the first case, that case eventually is granted, and then it's issued as a patent, right? And what we do is, before it issued as a patent, we chain that into, we file a descendant application that claims priority to the parent. So that is chained all the way through its entire life, because that first patent is foundational. It's the earliest description of your technology. And the reason why we do that is people who copy you, they're pretty smart. They're going to look at your claim and they're going to say, well, your claims require elements A, B, and C. And I'm just going to do A, B, or I'm going to do A, B, and D. And I'm going to design around your patent, right? So if we have that continuation going, there's always this uncertainty that whoever's trying to design around you have to deal with, is because they don't know what the claims are going to be. So very cheap way to keep your competitors at bay is through that use of a continuation process. All right. Now, the original patent application will not necessarily have everything that you have developed 10, 20 years downstream. Let's look at Windows 1 versus Windows 11. That's over, I think, at least a 20-year period, and there are tons of innovations in there. And I guarantee you that Microsoft got a ton of patents on them, right? But what we do when we work with client is before you have a new release, we would come in 3 months before that, and we will work with the team, right? You're going to have a product manager, and you're going to have the engineering guys, and we'll talk to them and we'll say, okay, in this new release, what are the new features you're going to tout in your advertising literature? And once we identify that, that means that we can hone in on that, and we can say, oh, these are the new features you don't want people to copy. Okay. Then we ask the engineers, how do you implement this feature? Give us documentation of that. And that's how we can pull information out in a market-driven manner. Now, sometimes an inventor might say, well, these features aren't mentioned. I've come up with a super neat trick, but these features don't ever surface it up to be mentioned in the product, marketing brochure. Then, we'll assess with the team to say if those individual neat technology contributions should be patented. So it's a combination of it, but in my experience, driven mainly from the important product features claimed in the marketing literature, and then supplemented by whatever else some inventor might think, oh, I've created this super neat new algorithms to do X, Y, and Z. I just want to patent it because it's good for the business.